First, we're going to start with the basics. Estate planning basics. We're going to start with the will. I always start with the basics because they're really critically important, and it's important to understand what they are and why we need them. So I assume everybody knows what a will is. A will is where you distribute your assets, or the document that distributes your assets to whom you wish. Okay? That's really important because you get to choose who gets your assets when you die, with some exceptions. If you don't do a will, New York State has a will. New York State's will tell the world where your assets will go. You have a choice. You can choose between New York State's assets, or New York State's will, or you can make your own will. I always default to making your own will. I think it's a much better choice because allowing New York State to make your will may not have your assets go to those people that you care about the most. For those people in particular who are in unmarried relationships, then you really need to create a will if you want assets to get to a person who is not blood relation or married to you. So you really want to do a will. A will requires the probate process. That is the process by which you file your will with your death certificate and a petition with the court to have the court oversee the distribution of your assets. It's a process. We've been using it here in New York for hundreds of years. The process works. I'm sure you've all heard things like, oh, we've got to avoid probate. I don't believe that avoiding probate is the be-all and end-all. I do think that if on certain occasions where you can avoid probate, it's important to do so, or it's certainly helpful to do so, but it shouldn't be the only reason you're doing something. So the will distributes your assets to whom you wish, when you wish, and you must go through the process. Now, this probate process requires a 7-month waiting period, and more importantly, or as important, it requires a filing fee with the court. So keep those things in mind when you decide whether you're going to use a will or how you're going to go through the process. It also requires that those people who would inherit if you died without a will sign off on your will. They get to receive a copy and they get to sign off on it, whether you like it or not. So, for instance, if you disinherit a child from your will, that child still gets a copy and has to sign off that that's your last will and testament. As you can see, that could create a problem. So you need to be mindful of those things when you're going ahead and deciding what type of plan to use. Okay? But it is important and critical that everybody have a will as part of their basic estate plan. All right, so that's the will. So, basics number 2, healthcare proxy. Okay? Well, why is this important? Well, again, New York State has a plan for who's appointed to make healthcare decisions for you. You may not want the person that New York State has chosen for your healthcare agent to be your healthcare agent. So you get to pick your own. In addition to picking your own, deciding who's going to be your healthcare agent, you get to give them instructions. And those instructions tell us how you will be treated at end of life. Will we be using life-sustaining treatment? Will we not? For how long? Who will make the decision? What will we be doing with your organs? Will be donating or not donating? Or which organs will we be donating or not? Will we be burying you, cremating you? How will we be dealing with your body after you're deceased? All those things can be put into your healthcare proxy, in addition to appointing someone to be in charge of your body after you die. If there's an instance where someone there could be conflict after you pass, it would be important to decide who's going to manage those decisions when you're not with us anymore. So the healthcare proxy becomes more important for many things, many more than you might believe. Okay? So that's a big deal. Now, so that's part 2 of our basics. Now part 3, probably the most important, is the power of attorney. Now, I know everyone thinks that all powers of attorney are alike, but in fact they are not. Powers of attorney differ because New York State allows the attorney to add language into the power of attorney to enhance it, to enhance the powers, to create more powers, to create limitations. whatever you want to do. So the power of attorney needs to be well drafted. And quite frankly, using the simple form that New York State can provide is not enough. In this day and age, we need a lot more power in this. One of the things, so the power of attorney appoints someone to make legal and financial decisions for you. Okay? If you are incapable of making those decisions by reason of disability or even a temporary stay in a nursing home or even overseas for some reason, you will want someone to be able to make legal and financial decisions for you. It's really important. So, I can't express to you how important the power of attorney is. Also, the power of attorney needs to have expansive powers. Because what could happen is you create a power of attorney today. 10 years from now, someone that you care about may need that power of attorney to take action on your behalf. One of those things could be protecting your assets in case you need long-term care. It could also be protecting your spouse in case you need long-term care. If the power of attorney does not have the gifting power, then that power of attorney is problematic and all but useless to us when the time comes that you are incapacitated and need to go into a nursing home. We need the ability, we as the estate planning attorneys and the Medicaid attorneys need the ability to move assets out of your name. And if we don't have the ability to gift or move assets, then we do not have the ability to do estate planning and asset protection for you at the time of your incapacity. Once again, I can't express to you enough how important the power of attorney is. A well-drafted, well-constructed power of attorney is critical. In the event that something happens to you, New York State does not have a hierarchy or does not have a plan like it does with a healthcare proxy or the will for who will make decisions on your behalf. It has to be created by you, has to be signed by you while you're competent, has to be put in place, and has to have really a competent amount of language in here to make sure it works well. Okay? If you take nothing from me today, please take how important the power of attorney is in advance of any planning or any disability that you might have in the future. Okay, now I know I'm going fast because I'm trying to make up for lost time here, so I apologize again. The topic for tonight is really Medicaid and crisis planning. So with that, there's a lot of things that we need to talk about leading up into that conversation. That conversation is a really substantial and potentially mind-bending conversation. So in order to get to that point, we need to understand some of the basic elements. The first basic element I already talked about was the power of attorney. Empowering someone, your spouse, your children, whomever, to do or make decisions on your behalf if a crisis occurs. Critical. Without it, the crisis planning invariably cannot work. So number two is having an understanding how the different aspects of estate planning work. So I want to talk about, for a minute, trusts. So I'm going to talk about two trusts. First one is a revocable trust. Now, the revocable trust is a wonderful tool for certain circumstances. It avoids probate, it can assist in asset management, and it can prepare your estate get you very organized so that at your passing or disability, your assets are properly funded and manageable by the people you care about. One of the things with a revocable trust is you can put assets into it and you can take assets out of it anytime you want. You can also revoke the trust, which means you can eliminate the trust's existence and take all the assets out of it. Because you have the ability to put in and take out at your will, that means that if you go into a nursing home, the nursing home, or Medicaid as the case may be, has the ability to itself reach into this trust and take your assets. What that means is, for our purposes, you cannot qualify for Medicaid if you have assets in a revocable trust beyond the Medicaid limits. I will in a minute talk about the Medicaid limits, again, explaining to you how this crisis planning works. So, revocable trusts are wonderful tools, but they are not tools that we generally use for crisis planning. They are tools we can use for pre-planning, That's a topic for another night, unfortunately, but there is a way to use revocable trusts and wills for pre-planning for long-term care. Let's talk about the tool that we must or usually use for crisis planning, and that would be our irrevocable Medicaid trust. And I'm going to explain it to you the way I explain it to my clients. In an effort to make it understandable, I draw it like this. This is, as you can see, hopefully this is clear, that is a safe. And the way I explain to my clients is that this safe is where we're going to put your assets. It's an irrevocable trust. And those are the assets that we want to protect. For instance, we may put your house in there. We may put some land in there. That's supposed to be a tree. I'm sorry if it doesn't look like that. Life insurance, investments, money, all can go into the safe. Can be owned by the safe. What can't be owned by the safe are IRAs, 401ks, 403bs, TSAs, TSPs, deferred compensation plans, any money that we call qualified money, which means that the taxes have not yet been paid on these funds. The taxes are not paid until the funds are withdrawn from the account. And those funds must stay outside of the trust. So for our purposes, I'll call them IRAs, in its simplest form, 401ks, things like that. Those must stay outside the trust and are treated as income for Medicaid purposes. And I'll explain a little bit what I mean by that. Also outside the trust is fixed income. Again, for our purposes, we'll talk about someone who is completely retired and has no earned income coming in. And the fixed income is the only income they have. Maybe it's pension, most definitely Social Security of some kind. Of course, we have what we call our mad money. Again, for our purposes today, it would be our money that we keep outside the trust that is not an IRA, it's not income, but it is money available for your use as liquid cash to be spent for your benefit. Generally speaking, we try to keep the mad money at $100,000 to $120,000, and I'll explain why. That becomes very relevant when I talk about what the Medicaid exemptions are and how we can spend down to get to the Medicaid exemptions, so that when we go into the crisis plan, we're well prepared to make sure you're eligible for Medicaid when the time comes that we're going to apply. Okay? So the trust can take title and can own things. One of the most important rules with this particular trust is whatever we put in here cannot be directly transferred back to the person who put those in there. People who put the assets in, oftentimes a husband and wife, are known as grantors. Those grantors who create the trust cannot reach in and grab the money and take it back out and put it in their pocket. That is the most important piece of this trust, because that requires, or that's how the trust protects the assets. Okay? By restricting access to those. So that's important. In New York, the grantor can be the trustee. The law provides that they can be the trustee. A lot of people, a lot of lawyers don't want their clients to be the trustee. I often will allow my client to be the trustee. I feel that they want to remain in control of their assets because the trustee controls these assets, okay? And so they manage what's in here, and they can decide whether or not the real estate would be sold. They can decide whether or not investments would be traded, sold, turned into cash, or cash would be turned into investments. If the house is sold, for instance, the money stays in the trust. And in turn, if this person moves to Florida, then this trust can buy a new house in Florida. The money never leaves the trust. It stays inside the trust and continues to be on its way to being protected. I haven't said, but you may know that it takes 5 years to get 100% protection in this trust. That is a really important number to know. That's a number that could change at any time. And that number becomes relevant when we talk about crisis planning, and then it becomes irrelevant when I talk about crisis planning. I know that sounds weird, but I'll explain it. The trust does allow the grantors, or I should say the trustees, to distribute assets from the trust, most often to children of the grantors during the lifetime of the grantors. So if money is ever needed to come out, if the grantors want to use the money as gifts to their children, if the grantors or trustees want to give money to their grandchildren for college, we could still use the trust to do that, and there's an easy way and a manageable way to make that happen. Okay? The trust itself will act as, or in place of, a will, and at the death of the last grantor, the trust then distributes to the beneficiaries. So for this explanation, I will use 3 beneficiaries. As you can see, I have 3 boxes here. I hope you can see that. Those boxes each represent a trust for the beneficiaries. Each one of these boxes is an irrevocable asset protection trust, also known as a separate share trust for the beneficiaries. These trusts are established because we want to protect the beneficiaries from what I call the 5 Ds. The 5 Ds are divorce, disability, disease, death, and debt. We want to make sure that the children, or the beneficiaries, whoever they are protected now from themselves, from divorce, from their own disability, from themselves being sick, running up medical bills, or being forced to be in a hospital or nursing home, their death, and I'll explain what that means, and large amounts of debt. We want to protect them from those kinds of things as well. As far as the death goes, the reason that's important is because if we leave money to a child, and that child dies 3 weeks after us, under most wills, that asset or that inheritance would vest in the deceased child's estate, and then would pass through their will, usually to their spouse. In this instance, the money is captured in the trust, and most generally would pass down to the children of the deceased child or the grandchildren, and would go into trust until they're 25 or 30 years old or something like that. Because of course young children are ill-prepared often to inherit, to receive an inheritance and manage it properly. So we want to be sure that it's in trust and managed and overseen for them by someone with some level of responsibility. So that's an important piece. So we're trying to protect the funds here, here, and here, all the way down the line. Really important. So this trust becomes an important component of asset protection if you go into a nursing home. In a pre-planning situation, if you create the trust and it's been 5, 6, 7 years since we put the money in the trust, and one of the grantors needs to go to the nursing home, the assets in here now are not accounted for Medicaid. They're not included as part of the calculation as to the level of resources the individuals have. In a minute, I'll explain the resource levels and what you're allowed to keep before you run into problems. Also, the IRAs. Important to understand that the IRAs are not considered a resource. So when someone applies for Medicaid in a nursing home, Medicaid looks at the resources and it looks at the income. So IRAs would be considered income, and the IRA distributions would flow into this fixed income category and become part of the monthly income calculation to determine how much the nursing home will get every month, if anything, as a result of the income. Okay, so I want to explain the income and resources portion of Medicaid a little bit clearer, and maybe this will start to make sense. So I'm going to go to page 2 here so I can talk about this. So what we have is income calculation. So let me explain it as simple as possible. Let's say we have husband and wife that have Social Security income of $4,000 a month, pension income of $2,000 a month, and IRA income of $1,000 a month. That makes a $7,000 a month income for retirement. Not so bad, $84,000 a year. Now, if someone applies for Medicaid and they're eligible, I'll get to the resources, but they're eligible, then what Medicaid does is take about $3,200 and that stays home with the community spouse. That 7,000 or that 3,200 subtracted from the 7,000, leaving us $3,800, and that goes to the nursing home on behalf of the institutionalized spouse, the spouse in the nursing home. This is a really rough calculation because there's more to it than that, but I'm going to give you the easiest, most understandable way to look at this. So that would mean out of $7,000 of combined income, $3,800 would go to the nursing home and $3,200 stays at home with the spouse that's living at home. That could be a problem because obviously $3,200 may not be sufficient funds to take care of the spouse at home, but there is no argument to be made to Medicaid that that's not sufficient funds. They don't care. All they know is you get to keep what your exemption is, you don't get to keep more than that. If you have, so let's talk about the resource side. I'm going to use a different color, and this will help. Resources. So the resources, this calculation allows the person at home to keep $75,000. The person in the nursing home, so this is the community spouse, this is the institutionalized spouse. Actually, it's about $16,000 now. Should have written that properly. Person in the nursing home gets to keep $16,000, and we get to keep a home, a car, and funerals. In its most basic form, those are the allowable resources. $91,000 of cash or other equitable resources, home, car, and funerals. Now, I want to be very clear. The cash allowances, this $91,000, includes cash value life insurance. So people always ask me, well, how can they take my life insurance? Because they consider the cash value in that life insurance part of your cash exemption. So you might have a life insurance policy with cash value of $18,000, but the death benefit might be worth $50,000 or $60,000. Because of that, it's really, really important to protect that life insurance policy, because the difference between the cash and the death benefit is something that your family would end up with, and it's a very important piece. So we need to consider how we manage and protect life insurance policies. Okay? But this is the resource calculation for someone who is going into the nursing home. So not a lot of money that can be kept as an exempt resource. Now, there are other exceptions to this. There's many exceptions to this. I don't want to get into too many of the exceptions. We'll talk a little bit about the exceptions as they relate to transfers. But under this scenario, those are the basic exceptions, or basic exemptions. Every situation is different. Every situation might allow for more resources because depending on the level of income, we might be able to protect more resources. So that's a conversation that we would have to determine what your income is and how we can leverage a lower income to protect greater resources. All right, so how does this work with a real-life case of crisis? First, let's understand what a crisis is. A crisis is, I didn't do any pre-planning, but I'm going into the nursing home, or I'm in the nursing home. And now I have to determine what, if anything, I can do to protect some of the money I have. So your aunt calls and is going into the nursing home. You're the power of attorney, and you have to make decisions for her. And here's what she's got. She's got a house worth $150,000, and she's got investments in cash worth $300,000. Okay? Now, for our purposes, again, we're going to call these net after expenses, so after we've paid for funerals, because funerals are exempt, after we've paid the lawyer, which is not necessarily exempt, but it is a spend down. After we've spent the money down, this is what we have left. We have $450,000 of assets, and she's going into the nursing home. Client comes in, says, my aunt's going into the nursing home. This is what we've got. What can we do? First thing I ask, do you have a power of attorney? Yes, I do. Is it a good one? Yes, it is. If it's not, then we do our best to get to the nursing home to have the aunt sign a new power of attorney so that we have one that does have the gifting power. Because at this point, when we're in the crisis planning mode, we're going to have to start moving assets out of the aunt's name. So first thing we probably do is we take a look at her will. Hopefully she's got a will, and we create a trust, an irrevocable trust, in accordance with the terms of her will. Because the will and the trust must match each other so that whatever her last wishes were as to how her assets were going to be distributed at her death, they match the terms of the will. The trust matches the terms of the will. But then what we do is this is where we start getting into our crisis mode and do the plan we have to do. So we take this money here and we move it into the trust. And we put $450,000 into that trust. Okay? Now, that's not the end, because I'm sure everyone's heard of the 5-year look back. I explained the 5 years before. And I explained how it's relevant and then becomes irrelevant for crisis planning. The first relevant part is because we are to provide 5 years of records to the Medicaid department, when they see the records, they're going to see the $450,000 transfer. That initiates what we call a penalty. So we have to take action to remedy the penalty. So what happens here? I'm going to assume for the moment that this person, this aunt, has a $2,500 a month income. Okay? I'm also going to assume that the nursing home costs $12,000 a month, which is approximately where we are right now in Oneida County, New York, upstate New York generally. We take the $12,000 a month, we subtract it by $2,500, and we have hopefully a $9,500 deficit every month. That is what this person has to come up with every month to pay the nursing home. Now, in order to become eligible for Medicaid, the applicant, this person, must be at or below $16,000 in their bank account. That's why we had to move the $450,000. So we moved the $450,000. Now they don't have the money to pay the nursing home, do they? We've got a problem. So what happens is this trust is going to turn around and pay about $9,500 a month for a period of time to pay back or to make sure we pay the nursing home. Now we have to calculate how many months this person has to pay back. So in upstate New York, New York State has determined that the what's called the regional divisor is $11,300. That regional divisor, when utilized against the transfer, will tell us what the penalty is. So for instance, if we transfer $450,000 and we divide that by $11,300, what are we going to get? Let's call it roughly 44 months. Plus or minus. Maybe it's 43. That 44 months is the duration that Medicaid will not pay for the nursing home. And at the end of the 44 months, you can go back to Medicaid and say, hey, will you pay now? And they will say, sure. Here's the problem. During that 44-month period, you don't have any money if you've given it away, or you have to get all of it back and spend it to pay for the 44 months. By the end of the 44 months, you have $0, nothing to leave your family, and if you're lucky, you have little more than zero, because you may have ended up spending more than the $450 to get there. So our job is to figure out how to save some of this $450. So again, we transfer the $450. Now, 11,300 is 20,800. We take our 450,000. I actually have to get a calculator out for this to make sure this is going to work right. How's that? And we take 450,000 divided by 20,800, and we get 21. Call it 22 months. So we have a 22-month penalty. So how did I do that? Well, first of all, what's important to note is the original penalty was 44 months. What I did is I cut that penalty in half to 22 months. And how I did that was, we're going to pay $9,500 a month for 22 months back to your aunt. During the 22 months that she is waiting to be eligible for Medicaid, we're using the $9,500 a month to pay for the nursing home. So, we paid about $220,000 to the nursing home. We have $230,000 left at the end of 22 months. And regardless of how long your aunt stays in the nursing home, whether it's 23 months, 24, 10 years, that money stays in the trust and Medicaid can't get their hands on it because we've protected it using this crisis plan. Now, I know that's confusing. And I know it's difficult to understand what I just did. When I first learned it 17 years ago, it was difficult to understand it. So I'm asking you not to try to understand the process so much, is understand the result. And the result looks like this. If you've got any amount of money, I don't care what it is, 100,000, 200,000, 300,000, understand that in most instances, we can protect at least half of the money and get that money to the family and get mom or dad or your aunt or your uncle on Medicaid while protecting those funds. Even if the person's already in the nursing home, we can still do that. What does it require? A good power of attorney, that the assets haven't already been spent, and that we can take action on their behalf to protect some of these assets. Okay? We also have to have a willing and active participant, which means the power of attorney, the person who's been empowered to make these decisions, is willing to do the work because it is work, and is willing to work with us or work with an attorney to get this stuff done. I'm not going to tell you it's easy, and I'm not going to tell you it's fun, because that would be an out-and-out lie. It's a lot of work, and it can be aggravating and frustrating at times. However, the result is that you're going to have some money protected there. And also, depending on how much money is there might be more incentive to get this stuff done. So, this is our crisis plan. Now, I want to talk about, if I may, some of the exceptions to traditional Medicaid crisis. Because the crisis, while using the trust and the planning techniques and the promissory note, the payback of the money is a great plan. It's not the only way, and in fact, there are better ways to protect more assets if feasible. For instance, if you have a disabled child, you can transfer your home to them without a penalty. If you have a disabled child, you can transfer assets to a trust for them. That's important. Okay? If you have a child who has lived in your home for 2 years and assisted you with your medical needs, taken you to medical appointments, made meals for you, cleaned your house, did your laundry, shopped for you, all these things, then you can transfer the house to this child with no penalty. That's a big deal because we do often see children moving home to take care of loved ones. Has to be a parent moving home to take care of a parent, and has basically given up perhaps their own house, has given up perhaps a job, changed their retirement plans to care for their parents. In that instance, we can transfer the home to them without a penalty. That could be a very big deal depending on the value of the home, and certainly as you go downstate, it becomes a bigger deal. Or if you're dealing with 2021 valuations, right? Houses are worth more. We're talking about a pretty good deal. You can transfer a house to a sibling who co-owns the house with you and lives there. So I have siblings that live together. They own the house together. Mom and dad left them the house. They both live there. One of them goes in the nursing home. That person in the nursing home can transfer the house to their sibling who's living in the house. No penalty. That's important. I'd also have clients who decide to move to their children's house. And in so doing, they give the children money to put an addition on, or improve the house, or build a new bathroom, or whatever it is. That transfer of funds could be penalized at some point. However, if in exchange for that transfer, the parent is given the right to live in that house for the rest of their lives, and they live there for at least 1 year, then that transfer is no penalty. So again, there are ways around these things if the facts and circumstances provide that we can do these things. I'm sure everyone's heard about people being able to stay at home. The last webinar I did was on home care, and I talked about your people staying at home, and children actually caring for them and getting paid for that. If you didn't see that one, or if it didn't get saved, we do see a lot of kids who are taking time to take care of their parents, and they can get paid for it through home care Medicaid. Home-based Medicaid is going through some changes right now, and it's a really an unfortunate situation because the caregivers are getting paid by the insurance companies minimum wage to provide care for your loved ones. When unfortunately at whatever it is, $13.10 an hour minimum wage, they can go down the street and work at pretty much any store or any fast food restaurant and make $2 an hour more and be far better off at the end of the week. And so the issue is, the big issue now is finding caregivers to do this. And if you have a child or a loved one who's willing to do it, they may be giving up a lucrative job to take on a minimum wage job to take care of their parents, which they may be okay doing because it's their parent. But it is a trade, and but it is creating a lot of issues in the marketplace for home caregivers. People don't want to go on payroll and earn minimum wage to provide care at home. They want to make more money than that, and it's a real strain on the home care economy, I should say. So I've talked about different exemptions to the Medicaid crisis situation. All of these, not all of these are available to everyone. Obviously, certain circumstances have to be in place. But you need to speak to your elder law professional to determine when and if any of those exceptions apply. With respect to the crisis plan, creating a trust, transferring the assets, using a promissory note, and engaging in a plan that will protect assets. This is not something that you can do alone. And quite frankly, it's not something that most attorneys can handle because there are so many technical issues related to it. It's got to be someone who does it regularly. So I'm happy to answer questions that anybody has. I know that, and I'm not sure how the questions work on Facebook Live, so I apologize. But what I am happy to do is I'm happy to give you my email address if you do have questions, and do my best to answer those at a time and place that I can. If it is a complicated circumstance or a series of questions, I may suggest we schedule a meeting or a phone call if it's worthwhile. If you do really have questions that are going to dig into some of the facts related to your loved one or your family, it's probably worth a sit down then. Again, if I wasn't clear already, make sure you have a good power of attorney in place. I cannot express to you any harder than I have how important that is to have. I get people that come in, they're 70, 75, 80 years old, they don't have a power of attorney. They may have a will, but the attorney didn't do a power of attorney. It is an integral part of your estate plan, your basic estate plan, to have that. So please consider and check your own documents. One of the things people are doing is they're having documents that are 10 years old, 15 years old. The law changes, times change, circumstances change. You need to review and update your documents on a reasonably regular basis. Reasonably regular would mean I would want you to review your documents every 5 years, if not sooner. Anything past 5 years, you really need to check into it. One of the things that is critically important with respect to estate planning that a lot of people don't take into consideration is the money piece, the funding piece. You go and create a will, and your will says I'm going to give all this stuff to people. But your money, your assets, have a different plan because you might have designations on those. You might have beneficiaries set up. You might have joint ownership. You might have things that will interrupt your wishes on your will. Those things override your will, and you need to understand how that can subvert your wishes. Particularly, and this is really important if anyone's watching who has young children, people with young children have to do this properly. If your kids are in their 40s and they receive an inheritance and it goes into their pocket, that's one thing. You have someone who's 8 years old and they receive an inheritance, it can't go in their pocket. It goes into a guardianship account. It's overseen by the court. They get all that money on their 18th birthday. Literally their 18th birthday, they get the money. This is a bad result if you've got young children. Think back to your 18, to when you were 18, and if someone dropped a lot of money into your lap at that point, how that would work out. So, really important that you have a will prepared if you've got young children, and that it's properly funded with life insurance and IRAs and stuff like that. Okay? Again, the best advice I can give you is to make sure you talk to someone who does this every day, so they can guide you and help you make sure you have the right amount of life insurance that's payable to the right spot, all that stuff. I also would encourage you to consider life insurance. I did a webinar in the beginning of December. I talked about 6 new modern uses of life insurance. I even came up with a couple more after that. But suffice to say that using and leveraging life insurance now to protect against long-term care, income taxes, capital gains taxes, all of these things are really, really important. If you have a blended family, if you have disabled children, if you have a business that you want to pass on to one child but can't pass it on to the other children, life insurance. There's a lot of reasons to consider life insurance as an important part of your estate plan, or your portfolio, I should say. So, again, sit with a professional. Understand the issues that are that your life faces, and determine what might be in your best interest to have. If you do have young children, I can't stress to you how important it is to have life insurance. Consider 10 times your salary as a basic metric for life insurance. It's really, really important. Okay? All right. So I know I blew through the Medicaid stuff very quickly, and I know it's difficult to understand. My goal today was, and again, I apologize for starting late, but my goal today was to ensure that you had at least a basic understanding of how it worked, and more importantly, that there are things you can do, pre-planning, crisis planning, to be ready for this. If you get the basics in place, at least if a crisis comes along, there's things we can do. Okay? All right. So I see that I'm a few minutes past normally where I would go. I wanted to get the full explanation. I usually go about 45 minutes. I see that the timer tells me it's 45 minutes on the dot. So, again, I don't know if there's a way to ask questions on here, and I apologize that my lack of technical skill has impeded my ability to manage these webinars at the highest professional level that I would like. However, please feel free to email me, and I'll put my email up here, rkh@hilton lawny.com. If you choose, you may shoot me an email with some basic questions. If it looks like it's more complicated than I can do in an email, I'll suggest we do a phone call or a meeting, or even a Zoom conference. Okay? I want to thank you for your time and your patience tonight. I do apologize for speeding through this again, but I do want to make sure that everyone has at least an idea of what we're dealing with and answer any questions in the future if you haven't. Thanks, everybody, and have a nice night.